actually starts. I looked at
We're down here pretty good. Yeah.
Sure, yeah. I could have just done my work clothes, but making me look bad.
Well, then I could dress down and I wouldn't look as bad, so.
I have my sweater on, it's cold out there.
It is cold.
Do a suit next week.
You're good. T-shirt and shorts, you can go Fetterman if you want.
No problem there at all, so.
Your fellow council members may feel differently and put in some type of dress code, but.
Remember when they come in after work, I was in the suit all the time, made them feel bad, except for Chuck, he never changed me. Didn't make him feel bad.
I gave all my suits away when I quit Simplot or retired. I got one left repairing it, so.
Okay, it is, I think we're working, sounds like it. It's just at 4:30, so we do have a workshop scheduled. I know we do have a couple council members that are running late, but I think we'll go ahead and start so we can get going and then be able to try to get through it. So I know we have a lot to cover on it. So the workshop is for discussion regarding the city employee performance evaluation form and process, and then after that we're going to go into some training by our city attorney regarding land use and legal affairs. So Shelley, we will begin with you.
Okay, good afternoon, City Council, Mayor. I'm Shelley Boggy, HR Director, and as you may know, the city has been working on a new form and procedure for employee evaluations, performance evaluations. It's in your packet. There's a policy, there's an evaluation form, and then there's an employee self-evaluation form. So the forms are all on your agenda for tonight for your approval. But I wanted to take a few minutes just to review this information with you and answer any questions or concerns that you may have about the process. As you know, performance evaluations, if they're done well, can be a meaningful tool for communicating good and poor performance to employees, as well as documenting that information for employee recognition, including pay increases. So I've been working with a supervisor focus group. A number of supervisors were interested in helping in this project, also working with the mayor to create the forms that are for your approval tonight. We've designed the evaluation to really be a living document so that it gets discussed with the employee at least quarterly and then submitted to HR at the end of March of every year. So we thought the evaluation period would be April through March, and that would go along with kind of nicely with our budgeting cycle. The group also created that employee self-evaluation form. It runs kind of concurrently with the performance evaluation, and then it also asks the employee a number of questions at the end, kind of questions that have been found helpful to determine retention of employees. So upon your approval, HR is going to be doing some training for supervisors over the next few weeks on setting performance expectations, giving feedback, using the new forms to evaluate performance. We're also going to be getting information out to employees on what to expect with the new forms and the new process. We plan to evaluate employees with this new tool for January through March, so just this first quarter is kind of our trial, and then we will make any necessary modifications for that next annual evaluation period, which will be April 1st through next March of 2025. Just of note that the fire department is using a different software. They are using TrackStar, and I've been working closely with Matt Shoup and kind of involved in that process. The policy does require that HR approve whatever evaluation system and form and process that's going to be utilized. I'm also working with police, and we're looking at using the same evaluation form but tweaking it a little bit for sworn police officers. So that's in the works. The forms will be created in a fillable PDF format, and you have the forms in your packet. I just kind of wanted to point out we did have, it has the ratings at the top, the position's key responsibilities that we're gonna pull from the job description, and then they're divided into 3 different categories, basically getting things done and what those competencies are, contributing to the team and culture, what those competencies are, and then improving the work and what those are. Place for performance goals and objectives and employee comments. And, like I said, on the self-evaluation, it runs pretty, concurrently with the evaluation form. And then at the very end are those, questions that kind of assess retention. So, I believe that's everything that I had for you. With that, I'll stand for any questions or comments, discussion.
Very good. I see microphone buttons being pushed already, so Councilor Doty.
Thank you. I'm glad that the key job responsibilities got added. I see you put that in there, so that'll be great, so that people actually know what they're responsible for and that it's covered often. Is there anything in policy or procedure to do one for probation employees? Generally, it's 1,040 for civilians. Police officers are sometimes 280. I gotta be honest, I don't know how our city probation works, but I guess that's why you're here to educate me on that. But do we have something in procedure that says one will be done? It can't be done on day 1,040, right? If it's 6 months probation, we have to know how they're doing along the way to know.
So the city doesn't have a probationary period. The handbook speaks that at all times city employees are at will, so we don't have a probationary period. The fire and police do have a 12-month probation period each, and so we'll make sure those systems and the policies that go along with those identify that they'll complete one at the end of the probationary period. I'm sure that's probably already in place for them. To do some kind of evaluation when they complete their probation.
And there is no procedure then for, if an at-will employee is fired, there isn't a process for them to appeal that firing, or is there?
So if somebody is going to be terminated, certainly we use progressive discipline and we don't jump right to a termination unless something's egregious. We work through our legal counsel. Taylor Yett is assigned for most employee relations kind of things. We also go through ICRIMP for anything punitive. So suspensions or dismissals would have to be approved by ICRIMP, our insurance company. And then there is something called a name clearing hearing that is in the handbook. I'm told that there's certain circumstances that employees can use that, but it's to clear their names. Generally, I believe in the context of kind of maybe criminal kind of allegations against them. So it doesn't apply to everyone who is terminated. So that's the process.
Thank you.
Okay. Councilor Stanek?
Yeah. I was always curious, do city governments have kind of a standard job description or position description, like what does somebody's a director of streets? Is it kind of common through the whole thing? The reason I ask is, in my previous life with Simplot, I was a raw procurement director, and usually across the board with Lamb Weston, McCain Foods, all the other processors, there was kind of a standard that here's what a raw procurement director person does. Do we have that? I mean, did you look at that in this particular study or not?
Yes, so I would say the city has very well-written job descriptions. That being said, we are updating them and kind of reformatting them as we put them into NeoGov. Mm-hmm. So NeoGov is our new online application system that all the job descriptions need to go into. So we're working with subject matter experts, which is generally the hiring manager, right, when we're updating those job descriptions and putting them in there. But I feel really pretty confident since I've been here at the city that the job descriptions are well written to the point that they're definitely usable. And when we do the training with supervisors on, hey, how do you set expectations, certainly reviewing that job description is key, and that's going to be covered in our training.
Okay, but at this point, though, there's not a benchmark compared to other cities on what a director of street department does, right?
I would say I have not compared those job descriptions to other city ones, except as we've dug into, like, the class and comp study, or if I've had to write a job description. Certainly, we share with Boise and Meridian and Yampa. We share job descriptions and, kind of start with that.
Mhm.
So I would say they're pretty,
Common, or?
common
I mean, do you look at
across
other
the
cities?
lines.
Did you look at other cities, though, when we did this new evaluation system?
The evaluation system, no, that wasn't part of this.
Okay, and what about the job description? Did we look at other cities too then, or not?
Well, we're looking at the job descriptions as we move them into the NeoGov system. So we're looking, so far we've moved electrical, streets, and wastewater onto NeoGov, and so we've uploaded those, and as we do, we're looking at other
Mhm.
comparable jobs, if you
Okay,
will.
thank you.
Any other questions? Councilor Williams?
Thank you, Mr. Mayor. Shelley, thank you for, I'm sure, more hours than you care to admit to in putting this together. It's needed. Help me understand why we're doing this quarterly. My concern is, especially departments that have multiple employees, to go through every employee quarterly is gonna be really time consuming. Is that essential, or what's the rationale behind that?
So I would say that the trend as far as performance evaluations in just the world of work, the annual performance evaluation is going away. A lot of private employers they don't do them anymore. A lot of the younger generation, an annual evaluation is just not sufficient, right?
Mm-hmm.
So the training that I've been to most recently, they say, even for public employers, right? So government still does things kind of more formally, right? So I still think there's value in doing the performance evaluation. But what the trainer said was, if you're going to do evaluations in this day and age, you need to do them well, and they need to be living, meaningful documents that really serve a purpose. And in my experience, supervisors hate doing performance evaluations. If you've ever had to do them, and I'm sure you have, it's time-consuming, right? And there's nothing that creates more conflict with employees than a poorly written or an evaluation that has a surprise in it. And so what I don't want to create is something that is going to create conflict or drama or emotion or that kind of thing. So I think if we can get our supervisors meeting more regularly and giving good feedback, and if they know how to give good feedback, that it's going to be conversational. And so our hope is, again, that this can be a living document where they're meeting with employees and giving feedback. So if you can see, I did the quarterly ratings. So this document gets pulled out quarterly. We talk about it. We document the details. And then at the end of the quarter, when we fill that out, that goes to HR. So it's not at the end of the year, I'm trying to remember, dig out files, dig out notes, and put together something. I have a living, breathing document that I have worked with this employee quarterly, and so it's very fresh in my mind, and it can just be sign off quarter 4, turn it into HR. So we're hoping that it is more user-friendly for supervisors, not so tedious, and that it's really meaningful, timely feedback for employees, which is what they want.
Have we checked with some of the departments to know, though, whether this is going to be overwhelming to them to have to do this quarterly? I have a lot of experience with the police department. There's a lot of employees in the police department.
Yeah.
And to have to do this quarterly, I know the police department already does reviews on their employees, right? But they're working with you to revamp that?
That I have seen. Since I've been here a little over a year, I have not seen one completed performance evaluation on any employee. That's of concern to me, but I do think the former process of the KRAs has kind of gone by the wayside. What I've heard about the KRAs is it was just a check. Everybody meets it. And so what is the value in that, right? If everybody gets it and everybody checks off, what is the value? So again, we're trying to create something meaningful where the employee gets to know what I'm doing well, what I need to work on, how can I improve, feel supported and like I'm growing as an employee. So I think it's really important that it is a kind of a living, breathing document. And I did, early November, I think it was November 9th, I had reached out to all the supervisors saying, hey, I want to get together a focus group and work on this performance evaluation. Because it's a difficult thing, right, to embark on. So we gathered in here, and probably a group of about 20 to 25 supervisors were very much interested in this whole process. And we spent some time talking about what supervisors love and hate, what employees love and hate about it, right? What do we want to evaluate? How do we evaluate? What are the ratings we want to do? We spent some time in small groups and together and kind of went through that whole process. Then I asked for an even smaller group to kind of help me fine-tune this. That small group was Bob Nelson, the electrical superintendent, Morgan Besaw, the planning and zoning deputy director, and Sergeant Scott Krepper from the police department. They were my small group that we met over at Streets and kind of refined all of these documents into kind of what you see tonight. Those have definitely been shared with the mayor, with all the department heads, asked for feedback. I've gotten some feedback and tweaked it a little bit. And so this is kind of the final document before you.
And I appreciate what you're saying. I really feel like quarterly is going to be more than is essential to have that living, breathing document that you want. I could see having a 90-day review for a new employee, but for an ongoing evaluation system to be quarterly, it's going to become, I'm afraid it's going to be creating work that we don't need to create for staff, while I think what you're on to is essential and needed. I agree with you. It's almost shocking to me that we don't have an employee evaluation system. So again, thank you for putting hard work into creating this. It's necessary, and in fact, I think we need to get this together before we add any more staff. Let's not hire any more people until we're able to determine that the people that are in these spots are doing the right job and are the right people for those spots. Because if we don't have a way to evaluate the people that are currently doing the jobs, why would we be adding to those departments? So I'm glad to see we're working on this. I just really don't agree with the quarterly being best practice and best use of our supervisors' time.
So I would like to make a comment, because I do believe, since I've been here a little over a year, we have been dealing with employees who are not meeting performance or attendance expectations. So I do think, even in the absence of a performance evaluation form and process, we still are working with supervisors to evaluate and assess and address performance, and making sure that we have the right people in the right jobs and that they're doing the job for which we are paying them to do, and those kind of things. So,
and let me interrupt you just for a minute, because you said something that's really important. If an employee isn't meeting the standards, we shouldn't wait for a quarterly review
exactly
to address that anyway. And so I don't think we need this to be quarterly to keep up with those employees that need coaching, because sometimes an employee just needs to be helped along to be better. We can do all we can as a supervisor to make them good by coaching them. And so that's part of what that remedial process is about. A supervisor that's not doing that when there's shortcomings is a different problem than us not having an evaluation system.
Right, and I guess what I'm trying to encourage is communication. So in my training that I've been putting together in anticipation of approval of something, right, it talks about employees want feedback. And it also talks about supervisors already think they give sufficient feedback, and employees are disagreeing with that. And I would also say that some of the younger generations, they need more feedback. It's almost like they need daily feedback, weekly feedback. And I can tell you that employees come into my office or my staff's office, and they will tell us things for which they should be telling their supervisor. And so 9 times out of 10, we are pointing them back to their supervisor with some talking points to say, hey, you know, you need to address this with your supervisor. But it's about resources that they need, it's about training that they want, it's about difficulties with processes and people. And so I think the more we can encourage, and I certainly want to do things that are more efficient for supervisors, but I think if we can train them to do this more ongoing conversation, I think there'll be less time in sitting down and doing kind of the function of it, if you
And
will.
I feel like I'm arguing with it. It certainly is my intention.
Oh, no, I don't take
Sounding
that way.
argumentative. I agree with all of that. I just disagree with this being quarterly. And if it's on the consent calendar, if it weren't, I'd vote no simply. In fact, I'm against it simply for the fact that it's quarterly. I realize this is a product that can be adjusted and amended and worked on as we go forward, but I think quarterly is going to create a burden and a workload for supervisors, especially in those departments that have so many employees, that it's not going to give us what we need. And these other things you're talking about, like being better communicators, we need to work on in helping our supervisors understand how to be better coaches, how to be better motivators, and how to be better communicators. And all that, I think, is a separate issue than this. And so simply for the fact that it's a quarterly requirement, I would be a no if I could vote on that independently. In fact, I don't know if we need to remove it from the consent calendar for that reason, Mr. Mayor. I'm not concerned about it.
Yeah. Councilor Doty, you had
So I have a couple of pros with it being quarterly. Having written many police evaluations, I do concur at the end of the year, you're pulling everyone's out and you have everyone in front of you at that time and you're trying to do it. Some of the most challenging things in the police world was when you switch supervisors and you don't have any documentation from the previous supervisor. This is very simplistic compared to ones that I've done at the state. They would take hours to prepare. This looks fairly quickly unless you're doing super well or poorly, which they should be on a PIP or some sort of action plan shortly thereafter you've talked to them if they haven't. So I would say that, one, because we haven't had evals in so long, I think it would be good to do it quarterly. Two, especially in the world where they do change supervisors often, at least you have some documentation there. Besides, I'll give you an example. When I retired in September. A new major came in and took over and had to write the evals on all my people. And I didn't have an eval written for that year because we don't do them quarterly. We do coaching and counseling quarterly, but not some sort of eval. So it wouldn't stop me from voting for it tonight. So those are just, I also understand what you're saying, which are the cons, but those are a couple pros coming from just a law enforcement perspective.
All right, thank you. Councilor Dintenberg, you have a comment?
Shelley, first of all, thank you for putting this together. I think every organization needs a performance evaluation. I think performance evaluations serve most the people that are underperforming and the people that are overperforming. And so something you said struck really close to me, and that is I have had less stress in my life recovering from a major surgery than I have during performance evaluation time period, literally, and that's...
Writing them or getting them?
Writing them,
Or both.
writing them. And that's because I look down through this form here, and I tend to agree with Councilor Williams. There's like 100 blank boxes. You're asking me to make 100 value-based decisions over a year. And I'm wondering if we can't just resign that we pre-populate everything in this to be a 3. Just pre-populate it for the supervisor. So that way, all the employees know that they're meeting expectations because they're employed. If they weren't meeting expectations, they're not employed. And manage the performance evaluation by the exception rather than the general. I agree with Councilor Williams. I think it's too cumbersome on a quarterly basis.
Mr. Mayor?
Yes, Councilor Doty?
So, but that's not necessarily true. If they're working on a PIP or an action plan, they would still be employed if they're meeting the goals of the action plan or they're trying to work through that. So if the quarterly eval were to come up and they're on a PIP, a performance improvement plan, they would still need the eval because they wouldn't necessarily not be working for us yet or terminated yet, as long as they're working through that PIP. Again, I get both sides. And maybe it's because my experience, this one looks pretty simple to me, to be able to buzz through fairly quickly. I agree it does put the employee in front of the supervisor, which sometimes does not happen until that employee gets an evaluation over a year. Maybe some more training. I mean, there's just several things. But I do like the quarterly eval, maybe because it's just so simple compared to what I've seen and had to do myself. And again, just because I think it's gonna take a while. We haven't had quarterly eval, I mean, there's none on file. And maybe it can change in the future, but some folks haven't had one ever since they've been employed here, so.
Councilor Shattuck?
Yeah, Mr. Mayor, just one more comment. I have to agree with, Councilors Dittenberg and Williams also, because the experience I've had is many times when you have them too often during the year, the supervisors have to go through them so fast to get them in on a certain time that the accuracy of them sometimes isn't what it should be. The other thing with a city in for instance, a street department, the duties during like the winter months sometimes can be altogether different than you have in spring, summer, and fall. You just don't do the same thing. So I would prefer an annual one too. Maybe a semi-annual one to catch up now. Maybe one in 6 months, and then after that an annual one. But quarterly, I think too many things are missed in quarterly because they got to do it too often. So that's my opinion. Thank you.
Councilor Register.
I'm just catching up, but, I was reading through some of this, and I kind of agree too. I'm wondering if you can do a, sort of a check-in, like a yearly one, and then a check-in maybe halfway through the year, so that it, kind of puts them in front of the supervisor. They can talk about anything they need to correct before that year comes up, that kind of thing, be aware. As opposed to the quarterly thing, it's almost like once you get one done and go through all your people, they're writing another one, depending on how long it takes or whatever. I just think as an employee myself in city government that it would have been helpful for me to have, well, we didn't have them, but it would have been helpful for me to have one every year that, was accurate and depending on what we were doing it for. But then a check-in halfway through so I knew what was coming or what I needed to work on before that annual one came, maybe.
Okay.
I do, just one more comment real quick. So we were hoping that we could evaluate employees by the end of March because we're hoping to create some criteria for pay increases so that the recommendation is not just for straight across the board COLAs this year, that part of that would be COLA and part of it would be discretionary performance based on some kind of criteria, and we wanted to see if we could develop the criteria around the performance evaluation. So that's why we wanted to try it for this first quarter, just to see how that worked and where the evaluations fell, and that Ray Lynn could use that as far as the budgeting and the criteria and what we bring before you for potential pay increases. So I don't know if you're open to using it just for the first quarter to evaluate employees for January, February, and March, and those get turned in and we can see how it goes. I'm certainly open to making it less, even just an annual, and then working with the supervisors to try to get better dialogue with employees. I think it's super critical in retention that they build those rapport, and I can't tell you how many employees do not talk to their supervisors and how many supervisors think they communicate well with their employees, but the employees are kind of starving for attention and feedback. And so I think we can find the sweet spot in there with this process. But I'm hoping that maybe something could get approved, and I can bring something back at the February 6th meeting that's modified based on the comments that you've given me tonight. So
I think I've seen some head nods about being able to do that this quarter. Is that
I would like to see that done as soon as possible, then maybe go on an annual basis after that first time around then. That would be acceptable to me, so.
Okay. Any other questions? Okay, any other comments?
No.
Okay, very good. Thank you so much, and thank you so much for the work you did on that.
Feedback.
And involving everybody, so, yep, very good. Thank you so much. Okay, that'll move us into our next item on the workshop. Mr. Hilty, the rest of the time is yours. At least up till 5:55, and we'll catch you off.
Understood. Is the PowerPoint keyed up and ready to go?
They're not just for that?
It is now. Or like that.
Make them as uncomfortable as possible, that way the meeting goes a little quicker. points on that. These
Yeah.
are interesting, right?
Right. I just couldn't remember which way to push it.
This is when Rob should be really happy that we have IT here, so he doesn't have to pretend to be IT to fix all of this.
Have some jokes you
You're
can tell or
welcome.
something to fill the time?
If they're like his predecessor's jokes, let's pass.
No,
on
no,
that.
I've got
So,
good jokes, but it's gonna take a while to tell, longer than it's gonna take for him to get set up. If this doesn't go well,
Arrested,
Jeff,
and they had
you
a
can just-
chance to.
I'll shift over to stand-up if I do. Yeah, that's fine, I can work. All right. Out of the gate, note the new firm name and new logo. We merged with another firm effective the 1st of January. We'd been talking about it and working on it for about 5 years. Anyway, new firm name, same great service. This is the logo. I was hoping it would be in color. I don't know what happened, but if you don't like the logo, I would just appreciate that if you keep it to yourself, because we're pretty proud of that. If you do like the logo, let me know, and there may be some swag here in the near future. See, that's the kind of thing, right, you could keep to yourself, Chuck. Example. All right, so here's what we're going to cover today. We're going to talk about legislative decisions very briefly, because just primarily to distinguish it from quasi-judicial decision-making, where we're going to spend some time, talk about the rules and the quasi-judicial decision-making process. And that arises, I think, as you're mostly aware, the council sits in a quasi-judicial capacity with respect to land use issues. That's about 90 or 95% of your quasi-judicial cases. There are some other ones, but when we talk about quasi-judicial, there should be, a flag going off thinking about land use decisions. We touch on a couple of open meeting law issues, and in particular how they relate to quasi-judicial. I had a request from a council member for some Fair Housing Act training, so we'll touch on a high level of Fair Housing Act and how that fits into your role. Again, that is a land use related item. Then finally, we're going to finish up with roles of the mayor and council. It's a pretty ambitious schedule. We'll take up all the time that I think we have, Mayor. I would ask two things as you listen to my presentation. One, I'm going to move through this stuff, and as you have questions, please interrupt me. And we certainly will have hopefully some time at the end for questions, but it might be easier as we go. So please feel free to interrupt me and ask whatever questions you have. The second thing is, we may touch on something that we don't have sufficient time for. You might want to go in depth on one or more of these topics. So be thinking about that, and you can let me know or the mayor know, and we can come back to some of these at some point in a little bit more detail. Let's talk about legislative decisions. This is where you're considering the adoption, repeal, or modification of generally applicable rules and policy. This is different from quasi-judicial. It can be discussed with members of the public. You can take input from whomever you want. You can talk about it outside of the public meeting process. The distinction is you are creating policy, not applying policy. Okay, so when you're talking about whether or not we should adopt particular rules applicable to all property within the R2 zone, that's legislative. And the Planning and Zoning Department will bring forward an ordinance that says lot sizes have to be this, or setbacks, or yes, you can have a barber shop in an R2 zone, no, you can't have a barber shop in an R2 zone. Here's what the special uses are going to be. Here's what the permitted uses are going to be. If you're thinking about an ordinance that deals with the R2 zone in general, creation of policy for the R2 zone, you're wearing your legislative hat. And eventually that'll come forward to you as an ordinance, and you're not constrained by these quasi-judicial rules that we're about to get into. But again, the key distinction is you're looking at a rule that's going to apply to everybody. You're not looking at an individual case and deciding how the rules apply to that individual case. That's primarily the issue. All right, quasi-judicial, and again, primarily land use. It's an action that in the nature when the local government body is applying the general rules, not making the general rules, not evaluating or changing the general rules, but you're taking the general rules you've already made, or some council before you has made, and applying those to specific individuals, interests, or situations. So you can see how the land use case emerges. You always have standing at this podium an applicant. The applicant is saying, I want to be annexed, I want a zone designation, I want a zone change. I need you to amend the comprehensive plan for me so that I can build my thing. I want a subdivision, special use permits typically decided at the planning and zoning level, but anything that falls within that land use where you have typically there's going to be a hearing and an individual asking you to approve their particular project. That's quasi-judicial, and that's where you would be applying standards, not making standards. When acting upon a quasi-judicial zoning matter, the governing board is neither a proponent nor an opponent of the proposal at issue, but sits instead in the seat of judge. Again, citing Idaho case law there. We all learned in our civics class about the three branches of government. There's the executive, the judicial, and legislative. Those apply in the city context. The mayor's the executive branch, right? He does the president things. The council is the legislative branch. You guys consider and pass the ordinances. You're the only body in the city that does that. But you also sit as judge. Okay, so you're also the judicial branch. And when you are acting in your quasi-judicial capacity, you're the judge, and you're deciding the case. And you're deciding the case based upon the rules that apply that are in place. And it's an important thing to keep in mind. When you are deciding whether to allow, for example, duplexes in the R2 zone or not to allow duplexes in the R2 zone, that's a legislative function. That doesn't trigger the same individual rights. It's a representative government type of thing. You can make that decision based on whether you think it's a good idea. It's a discretionary decision. Is this the best thing for the city or not? Based on how you feel about what should be in the R2 zone, how you feel about the development of the city, how you feel about duplexes as a land use, whether they are compatible with other uses in the R2 zone, in your opinion. Different in quasi-judicial matters. You don't have that level of discretion. You've got to look back at the rules that have already been passed that would apply. So if you have somebody who comes before you and says, I want to change the zone of my property, my specific property to R2, you've got to look at comprehensive plan issues. You've got to look at whether or not that's a spot zone. You've got to look at the existing rules and decide whether or not the request meets those rules. Make sense? Sorry, don't mean to be beating you up on this.
Since you're okay, I do have a question.
Yeah.
Can I ask it now, Mr. Mayor? Are you okay with that?
Yeah.
So I listened to the counselors up here read their little cheat sheet, or maybe some of them have it committed to memory, but it says something to the effect based upon the testimony given, the conclusion of law, and the finding of fact, and then a whole bunch of numbers, and then a statement. The fact that we say based upon testimony given, the conclusion of law, and the finding of fact means that our opinion really doesn't matter, right? We should just be looking at what the law is, what's allowable, and what we've already decided on, and whether or not we agree or disagree with, barber shops or duplexes in R2. If the law allows for it, we should be voting for approval because it meets the conditions of the law, correct?
Yes, that is correct. We're going to get into that quasi-judicial decision-making in a little bit more detail. There is a prerogative for the city council to determine what the facts are. A lot of times you may have a case presented with differing facts, and you do have the right to listen to the testimony and determine what the facts are. Once you've determined what the facts are, you do have to apply the rules to those facts.
Can I throw something in there too, Mark?
Yeah.
Sorry to interrupt, and you may get into this too. I think it is more complex. I think you're going to get into that of just saying, okay, this says this is allowed, that you can ask for this. And it kind of, I guess there's so many things that go into it, like if it's like the R1 that we've kind of seen, right, where you meet all of the qualifications. How do you deny it? But there's a lot of cases where there's gray area, and that's where the council needs to factor in the comprehensive plan. Does this fit in that area? And so that's where, so there are, and that's what most of them are. There are very few that are very cut and dry where it's 100% meets that code, like some of these are ones that we've seen, but most of them is if they're wanting to go, if it's a special use permit or, a rezone or annexation, does it fit with that area? If you're asking for a rezone from an R1 to a C3, even if all the boxes, let's say, are checked, but it's surrounded by R1 or there's no C3 commercials in that area, then that's where the council has to decide, is this an appropriate fit for that area? How is it going to negatively or positively affect the other properties surrounding it? So there are some that are very cut and dry and they do meet all that, but I'd say those are the exception. The majority of them is a lot more into it, and I'm sure you'll get into that. I just wanted to throw that in there.
No, you're absolutely right. It's never entirely clean, right? We would hope that, and what basically I'm describing is 2 + 2 = 4. Facts, law, or policy equals decision. It's never that easy. But I think the point I'm trying to make now, make sure you're aware of, is you got to go through the equation, right? It's not, I can ignore all the facts, I can ignore the testimony, I can ignore our ordinances, and just kind of do what I think is right here. That's not how land use decisions, no quasi-judicial decisions work that way. And we'll get into, a bit more detail about that, but good question. In Chambers versus Kootenai County, the court held that the governing board, which would be the city council, for our purposes, must reach their decision on a quasi-judicial matter based solely upon the record as established at the public hearing. So 2 things I want you to be aware of there. The record, okay, means the evidence and testimony that is presented to you. That's what you have to rely on in making your decision, and that has to be presented at the public hearing in a quasi-judicial matter. And there's good reasons for that. And it has its basis in due process, because you are dealing now with the individual rights of a particular person who's filed an application, and they want to know how their application, whether it passes muster with your laws. And so it'd be the same thing as what a court does. There is rules about what you can consider. So it protects everybody, those that are the applicants and those that are in favor, as well as those that are opposed, to know that your decision is going to be based on what you hear and what you hear at the hearing only. Because then, whether I'm in favor or opposed to it, I at least get to hear all the testimony. And if I think you've been told something wrong, I have a chance to get up and tell you why that was wrong. If I think the developer is running around the back door and talking to you at the coffee shop or on the phone or because he's your best friend or whatever, then I don't know what you've been told. Now, and that's a violation according to the courts, and this is the same in every state. That's a violation of due process rights. And so that's why I get, I think all of you have heard me say, even new Councilor Dittenber, don't talk to people about quasi-judicial matters, tell them to come to the hearing, and so we'll get into that here. An ex parte communication, ex parte means one party only, okay? Let me start with what that is. It's when somebody comes to you and wants to talk to you about a quasi-judicial matter outside of the public hearing, right? So the law says that's no good. Your constituents believe fairly and rightly that they should be able to come talk to you about whatever city business is of concern to them. They're not going to understand these quasi-judicial rules. They haven't been through this training. And so you can expect, and I know all of you probably have, received those emails. Hey, this subdivision on the corner of First and Emerald is a bad idea, and here's why. Or they're going to talk to you at church or at the gym or the coffee shop or wherever, and they're going to say, hey, you need to know that you need to vote no, or you need to vote yes, or whatever. When you have those conversations with constituents, what I would ask you to do is think about, is this a quasi-judicial matter or a legislative matter? If it's a legislative matter, you can have that conversation. There's no rule against it. So you can talk about whether there should be duplexes in the R2 zone. What you can't talk about is, Hilti's application for, a zone change or a subdivision plat or something like that. So once they're talking to you about a specific application, and again, generally, almost always, it's going to be in the context of land use. Once they start talking to you, you need to stop that conversation and just tell them, look, I know this is important to you. Well, you can deal with your constituents however you want. This is political advice, I guess. But tell them, look, it's not that I don't want to hear what you have to say. It's that I have to hear it at the public hearing. And if you can't attend the public hearing, email the Planning and Zoning Department or send us a letter or get us your statements in writing, and I will consider those, I promise you. I just can't talk to you about it outside that public hearing process. It's a due process issue. Stinking lawyers, you can tell them whatever you want, but avoid those conversations. Now, there is a way to cure it. Curing is not an exception. It doesn't mean it's okay to have ex parte communications and then go through the cure process. It's just that sometimes it happens when you can't control it, or when you forgot, or you didn't understand, right? I've had council members say, I got this email, I didn't realize until I was through the first paragraph that this had to do with a pending application, but I did read it. What do I do? So there's a cure process. An ex parte communication can be disclosed at the public hearing, including the identity of those involved and a general description of the communication. The purpose of the disclosure requirement is to afford opposing parties an opportunity to rebut the substance of the communication. So remember, this is all grounded in everybody gets to hear what you're going to consider. And if you hear something outside the public hearing, at the beginning of the hearing you say, I got an email from, John Doe about this, and I didn't read all of it, but I did read enough to know that he's concerned about the traffic on 5th Street. I passed along his, I told him to submit written comments to P&Z or to come to the hearing, but I do want, to disclose that I did have this conversation, so I know at least somebody's concerned about traffic on 5th. I think that's all you have to do, if that's all you heard. There's no magic to it, but at least it tells the people who are in attendance who might want to contest that, right, that somebody's concerned about 5th Street traffic, and I know that. I know that they're concerned about that. I've received that information. So the public can address it or not address it or whatever, but at least they know that you've been told. So avoid the ex parte communication. If it happens and you couldn't avoid it or were surprised or it snuck up on you, there is a way to cure it. All right, so let's get into the decision making. This is not one of my favorite things as a city attorney. This is a challenge. Quasi-judicial decision making is not easy. It is governed by the Local Land Use Planning Act, Idaho Code 676535. And I'm going to have 2 or 3 slides here that talk about what that statute requires of you as a land use body. It's the intent of the legislature that decisions made pursuant to this chapter, which is the Land Use Planning Act, should be founded upon sound reason and practical application of recognized principles of law. So that's a little bit different than your discretionary authority with a legislative matter. And it sounds like it makes sense. The court calls this a reasoned statement, and it is required on all land use decisions. Logical, great idea, very, very difficult. And frankly, you're going to have to rely on staff to help you with this. And we'll get into kind of how it works. But I think it's one of those laws that is well intended and logical and imposes a burden. And I've represented some very small jurisdictions that have planning and zoning meetings once a year. their folks are not really capable of doing this. They have to have help of an attorney or staff to do it. And from my perspective, what the court or the legislature is asking you to do is the same thing that a judge does when he rules on a case, right? When we have an appellate decision, they're determining what the facts are, and they're applying the law, and there's an analysis, and here's your decision. And that very much is what is described here. And we all know how controversial those decisions can be, even when they're done by Supreme Court justices. All right, moving on. Such approval standards and criteria shall be set forth in express terms in land use ordinances in order to permit applicants interested in, and interested residents and decision makers alike, that they may know the express standards that must be met in order to obtain a requested permit or approval. So, you love or hate developers, right? But, I've told, lots of folks, developers don't develop with yellow iron. They develop with a pencil and paper and a calculator. And they make lots of expensive decisions based on the rules that this body has already passed. And so when you have somebody coming forward when they want, a subdivision or an annexation, or they want a zone change, they have, before they got the interest in the property and spent the money to do the engineering and whatever, they've looked at those ordinances and come to a conclusion on their own, and maybe right or wrong, but they've come to a conclusion that they can meet those requirements, or they would not have gone down this path to begin with, typically. And so, the statute 67, 65, 35 basically expresses that everybody, the reason we're requiring you to do this is that everybody should have access to the rules that are going to be applied when they come forward and say, I want whatever it is, X. The decision shall identify aspects of compliance or non-compliance with relevant approval standards and criteria in the written decision. So this is where you get not only your facts and your law, but your analysis. This is going to be, ideally, the way this would work is you would conduct the hearing. The hearing gives you the evidence that you're going to rely on. You would resolve factual disputes. Okay, it's going to be a traffic problem. It's not going to be a traffic problem. Or, this lot is too small, or it's too steep, or whatever. You can listen to differing opinions on that, and you have the discretion to determine what the actual facts are. Who's telling you the straight scoop on that? You can decide that. Once you've resolved all the facts, you apply the standards. The standards they're talking about come from your comprehensive plan, your zoning ordinance, your subdivision ordinance, and the Local Land Use Planning Act, at least. And there may be other specific ordinances that apply, or statutes, depending on the type of application. So we're talking about, if I was going to print all that off for you, I'd have several inches of paper. So that's why I'm not entirely happy with the legislature on this. I understand why it's there, but it's a very difficult thing to do. All right. A reasoned statement explains the criteria and standards considered relevant, states the relevant facts relied upon, and explains the rationale for the decision based on the applicable provisions of the comp plan, relevant ordinances, blah, blah, we just covered that. But basically, this is language right out of the statute that talks about how you would go about this. Oh, and if you don't do a good job, then everything that you've done can be turned on its head by the courts. So this is where it comes down to, and I'm sorry if I've made this sound impossible. It's not impossible, but you do have to rely on staff. Staff, to get back to the point about how the council handles this from the dais is a little bit different, because the decision that you make is the written findings of fact, conclusions of law and order that staff typically prepares for you. And Mayor Wagner has done a lot to make our hearings more efficient. Under the prior administration, we would go through specifically the findings of fact and the conclusions of law, and I think that was a process that had been inherited from yet earlier administrations going back into the 90s or 80s. What went down there was not sufficient to comply with any of this. It didn't need to be, because ultimately the decision was that written findings of fact, conclusions of law, and order of decision. You as council members absolutely have the authority and discretion to review in detail those findings and conclusions and the order and whether or not they are accurately applying the facts that you determine to be the case, whether they are accurately applying the law, and when you see those things come through, typically on the consent agenda, you know, you're well within your authority to say, I don't think this is right. You know, recognizing that it's not an easy thing to do even for staff. It's not an easy thing for attorneys to do. But it is required by the law, and that's the way we do it, and that's the way every zoning jurisdiction does it. City of Boise, right, largest jurisdiction in the state, recently had the Supreme Court go, you didn't do it right. You didn't make sufficient findings, and we're going to undo everything that you did. It happens. And so, anyway, just to be aware of what's required there. It's much more than just saying, I don't know, do I think there should be a subdivision here or not? It's a much more detailed analysis than that. All right, I'm going to move on quickly to open meetings, and again, that, I guess just to sum up, that quasi-judicial decision-making process is a difficult one. We could certainly do more training on it. If it sounds like that would be desired by any of you, obviously my office is available to you on an individual basis. If you've got particular questions about particular cases, you can talk to staff about quasi-judicial matters if you're trying to figure out, you know, kind of what your role is and how to do your duty as a council member. We're always available to try to help with that. All right. I like this. This is out on the open meetings law. This is a prefatory statement that the legislature passed, and I really like it because I like being an Idahoan and I like what they have to say here. The people of the state of Idaho, in creating the instruments of government that serve them, you are an instrument of government, do not yield their sovereignty to the agency so created. Therefore, the legislature finds and declares that it is the policy of the state that the formation of public policy is public business and shall not be conducted in secret. That's the basis of the entire open meeting law. And so when we talk about what communications outside that might violate the open meeting law, it's because the legislature has decided that that should be done in a public meeting. That's the policy behind it. Couple definitions. A meeting means the convening of a governing body, generally understood as a quorum, which would be four council members, to make a decision or to deliberate toward a decision on any matter. Here's where it gets broad. Deliberation means the receipt or exchange of information or opinion relating to a decision, but shall not include informal or impromptu discussions of a general nature, which do not specifically relate to a matter then pending before the public agency for decision. I'm not aware that that exception has been really fleshed out or applied by the court. The thing I want you to focus on is that definition of deliberation means the receipt or exchange of information. Identify for me the last time you had any conversation or email that did not involve the receipt or exchange of information. It's all your communications. Okay. The question is whether or not it's relating to a decision that you may be called upon to make. So, you know, your communications about, that you all may have, right, about the employee Christmas party or something like that. There's not substance of decision there. But a lot of times when you want to reach out to your fellow council members, and mayor, you too, it's going to be about some kind of city business and some kind of decision that you need to make or want to make, or that is before you for discussion. And almost anything that you do in communicating with each other is going to be that receipt or exchange of information. So it's very broad, right? And that's why we're covering it. So the open meeting law requirements. So I guess the question is, what do I have to do to comply with the open meetings law if I want to engage in a deliberation? Notice, agenda, minutes are taken. There could be an executive session, as you're aware. There's a process for that. There are limited things that you can go in and discuss in executive session and a process for getting in there. But here's where I want to focus on is serial meetings and group emails. The law in Idaho is not super well developed, and this is in this area. So in other states, it's very clear that if 4 of you are engaged in an email chain, that is talking about city business, you are conducting a meeting and you're deliberating and you're breaking the law. We're not quite there yet in Idaho, but based on the broad definition of deliberation and the definition of meeting that we just covered, it is my opinion that if somebody could connect the dots and say, we had a quorum of council members all communicating with each other in an effort to exchange information, that's a violation of the open meeting law. And so when you're on these chain emails, so if you get something from Joanna that says, hey, we're going to have pictures at the council meeting at the first meeting in January, whatever. I mean, that's not the kind of deliberation toward a decision, right? But once you get beyond that sort of real mundane stuff into anything substantive, you should be concerned about violating that open meeting law. And so that's kind of the group emails. Group texts obviously would be the same thing. And then serial meetings, where we're not going to get all of us together. But Mike decides I'm going to go to Diana and I'm going to Chuck, I'm going to go get everybody's opinion on this. Kind of falls within that same category. So the law, again, is not well defined. I can't quote you chapter and verse in Idaho. We will get there at some point. And really my take on the open meeting law is it was created at a time when we communicated in two ways. We talked to each other, or somebody wrote a letter, right? I mean, really and so keeping track of records and what was going on in communications and stuff was much easier. The ways in which we can communicate with direct messaging and social media, emails, text, voicemails, all those things make this, and the public records law much more of a challenge. But anyway, I would just say, keep in mind, and be wary of those chain emails where there's replies and stuff going on, and whether or not, there's some kind of a chain meeting going on, a serial meeting, sorry. Again, I think that is a difficult one. I think it happens. There may be a place for it depending on how it's conducted, but we're very much into a gray area there. All right. Fair Housing Act. Had a council member ask about this, and it's come up a couple times at hearings. You're violating the Fair Housing Act, and so let's go over it real quick and talk about it. The Fair Housing Act prohibits discrimination by discriminatory practices that make housing unavailable to persons because of race or color, religion, sex, national origin, familial status, or disability. You would think, and typically, so the primary example of a violation of the Fair Housing Act is, I'm not going to rent I'm a landlord, and I'm not going to rent this to anybody who's got a disability. Right, that is a violation of the Fair Housing Act. It applies most directly to people who deal in property. They build properties, they lease properties, they sell properties, and if in those practices they're discriminating, then they're in violation. It applies to governing agencies as well, because you guys do make decisions or could make decisions that affect the availability of housing, and depending on the circumstances, could affect the availability of housing for people that fall into these protected categories. I know all of you well enough to know that those first 5 are not likely to be issues for you. You're not going to do anything on purpose to discriminate on race, religion, sex, national origin. And that's not to say you would on disability, but there's a little bit more of a direct connection between a zoning body and disability than there is on some of those other things. But really, the short story is that's what the Fair Housing Act prohibits. And so if somebody gets up and says, spouts off, right, you're violating the Fair Housing Act, you can ask them why they think that. And which categories, or how is this adversely affecting the availability of housing based on one of these protected categories? My guess is they're probably not going to have an answer for you, because it's a convenient thing to throw out, but somebody may not, your decisions really don't, come up and touch on this very much. But let's talk about about group homes, and this is people with disabilities. This is something that that does come up because the city does have regulations about group homes, and to have a group of disabled persons in your city, you could think that that does present potentially a risk to them or a burden on resources or something like that. The Fair Housing Act prohibits land use policies or actions that treat groups of persons with disabilities less favorably than groups of non-disabled persons. And the best way to think about this is, if there is a house wherever, over on Everett, and you don't have any provisions, you don't have any land use regulations that say 5 unrelated college students can't move in there and rent that property. But what if 5 disabled people want to do that, right? And that might present, you just need to be aware that those disabled persons cannot be treated differently than anybody else, right? So whether it's a traditional nuclear family, an extended family, unrelated persons or whatever. Now, I think there is provision if it's over 8 or something like that, that you can regulate that based on just the number of people that it would be appropriate to have in a single family dwelling. But that's applied again across the board, not specific to people's disabilities. FHA prohibits adverse land use actions based on the disability of individuals. Reasonable accommodations in land use decisions may be required under the FHA. That's something, if that comes up legitimately, you're going to see probably a developer or an applicant asking for that and basing it on the Fair Housing Act, and then my office is going to be involved, and that's not something that you need to kind of address on the fly. That's going to be a little bit of an unusual situation, and getting some legal advice on that would be appropriate, but just kind of be aware that it's out there. All right, this is just me, what to watch out for. We know what kind of people are going to be living in that apartment building, right? You've heard things like that. I've heard things like that from this dais. We don't want those kind of people. We don't want to encourage, that blah, blah, blah. Those are red flags, right? That once you start hearing people say, we don't want those kind of people around, the question is, well, what kind of people are they talking about? Right? Are they talking about, unmarried people or people who have, a religion that is in a minority or something like that? Those are red flags because, again, you're going to get to where you're finding a fact, and if you decide to turn that application down for other reasons, but you've had people testify in opposition that we don't like those people, that's where you can get into trouble as a zoning board under the Fair Housing Act. So anytime anytime that we deviate from talking about land uses about land uses, right? An apartment building versus a single-family residence or some kind of commercial development or whatever. Once we stop talking about that and we start talking about people, that's where some jurisdictions have gotten into trouble. Idaho County had a horrible one a few years ago where they were on the hook for millions of dollars for denying what was, I think, essentially sort of a group home type arrangement. And, you're going to have attorneys that know what they're doing that'll twist this against you and say, this is what you decided when you didn't really intend it. What about the poor? You'll note that poor is not a category of discrimination. And so if somebody says you have to approve this because you need to approve poor, you can't discriminate against poor people. So you have to have tiny lots or apartment buildings or whatever it is that they think where poor people will live. That's not relevant. It's not a violation of the Fair Housing Act to deny a development simply because poor people were potentially going to live there. I would say this. Oftentimes, there's a connection between poor people and some of these protected categories. Not maybe so much in Idaho, but across the country, certainly race issues. And disability issues can be, somebody can draw a line there, and so just be careful of it when you're thinking about the poor, right? All right, let's move on to mayor and council roles, and I'm going to move through this just in the interest of time. fairly quickly. I'll spare you the civics lesson in that slide. What I want you to know about what we're going to cover here is it may seem a little bit boring and off point, but it's going to be kind of a 30,000-foot view of where is the prerogative and duties and responsibilities of mayor, where is the prerogative, duty, and responsibility of council members. And the thing I want you to know is that it's, from my perspective, it's based on state law. And so we're going to look at what the statutes have to say about these relative roles. I've got some ideas about, from a practical standpoint, that come from, I guess, my experience being around mayors and councils for 25 years that I'll share with you at the end. But really, when it comes right down to it, if somebody says to me, well, what's the role of the mayor and what's the role of the council members, I'm going to default to the statutes. And so we'll go over those today. How you get along is the art of governance both ways. It's the responsibility of council members and mayor both to try to make that a working, positive relationship. Not a legal issue. And I've told clients lots of times, if I could figure out how to make people get along with each other, I'd be the richest attorney in the world. That said, right, my perception is you guys are doing a pretty good job, right? It's not without its bumps. It never is. But this is not like, should not be understood as me saying you guys have problems. I don't see that. And we'll get into a little bit of the details of why. From the 30,000-foot view, I think you know this, the mayor as the executive is responsible for the day-to-day operations of the city. Council is for general policy, certainly the legislative and sort of the prime directives, right? And then the mayor, so if we're going to have an ordinance that prohibits barking dogs after 10 p.m., that's got to come from the council, right? That's going to be an ordinance, a legislative matter. Enforcement is the mayor's responsibility, and again, that would be on the police department or code enforcement or whatever, but ultimately the mayor is in charge of those departments. And so that's kind of the generalized division. The mayor shall be the chief administrative official, preside over meetings of the city council, and determine the order of business subject to rules as council may prescribe, have a vote when it's divided, have the superintendent control of all the officers and affairs of the city, there's your day-to-day operations, preserve order, and take care that the ordinances of the city and provisions of state law are complied with and enforced. It does talk about presiding over the meeting, and I did have a question about agenda items, and I've been asked this question, and maybe by some of you, and certainly in other jurisdictions, how do I get something on the agenda? Or why is this on the agenda? Whose decision was it to put, and you probably will see me stammering and stuttering and not having a great answer, because the truth is, and Debbie I think can back me up on this, there's not really hard and fast rules. You've got different departments that deal with things, and you have some on your agenda tonight that require council action. Local improvement districts, annexing property into the municipal irrigation district, all the land use stuff that comes out of planning and zoning. So you got planning and zoning just telling Debbie, we need to have this on the agenda. And you've got the public works department, we need approval of this contract or whatever. And so a lot of it just kind of comes from department heads or people, not even department heads, but people in departments who know that council needs to do these things. Certainly the mayor puts things on there. I will call Debbie and say, I need an executive session over this or that. So there are no hard and fast rules for how that happens. And there are no rules for how council members get something on the agenda that they would like to see. What I would encourage you to do is go to the mayor with your request. And mayor, you need to accommodate those requests if you can. Another good way to approach it is during your council comments. I would like to see us consider X, Y, and Z on the agenda. Jeff, you did something and we shot you down because it wasn't on the agenda, but that's a prime example. At comment time, say, I think we need to do this and I would like to see it on a future agenda, right? And if you've got several council members nodding their head and the mayor maybe or whatever, it's eventually going to get on there. So there is no, I can't quote you a law that says the council members have the authority to put something on the agenda. But there's really nothing that says the mayor or the clerk or the attorney can do it either. It just happens. And so I know that's not a super satisfying answer. But those are my thoughts about how to handle agenda items that you'd like to see. Mayor, supervising city employees, the day-to-day functions. I'm going to go through these pretty quick. Again, stop me if you want to talk about anything. Enforcing the laws and policies passed by the council, the authority to do a quarantine ordinance, can declare a local disaster emergency for up to 7 days. That did happen in some jurisdictions with COVID. It had to be extended by council action. I think we did that here. Emergency holdbacks and spending. The mayor has the authority to veto ordinances passed by the council, subject to override by a majority of the full council. So that's out there. May call special meetings of the council, presides over the council meetings, as we talked about. Breaking tie votes. There are a few things that the mayor cannot break a tie on that require, the language in the code is the approval of a majority of the full council, okay, which for a council of 6 would be 4 of you. And there's a list of several things that never come up. Appointments of city officials. The appointed officials is one where the mayor cannot break a tie. Requires 4 votes to appoint or to remove. Did that wrong. To remove, it requires a unanimous council or the mayor plus 4 votes to remove. But to appoint requires 4 council members. The mayor obviously is the one that nominates. Okay, waiving the 3 reading rule. I think there's some stuff in the elections ordinances to talk about how you do elections. Sometimes requires a majority of the full council. Like going into executive sessions requires a majority of the full council. Okay, formulating policy recommendations for the council. Nominating persons to serve in appointed offices, subject to approval by the council. All right, removal of appointed officers. We just talked about that. Filling vacant council positions. Appointment and removal of members to city boards. All right, which gets us to some of the city council legal prerogatives. You're the legislative authority for each city. There are lots and lots of things in state law that require the city to act by ordinance. Every one of those things would be the council prerogative. Adopt local ordinances to protect the public health safety. I don't think it's mentioned in here. Maybe I'll get to it. One of the major things, as you're aware, that falls within that category is approval of the appropriations ordinance, the budget. That's council. Annexation of territory, adopting a comprehensive plan, adopting the zoning ordinance, subdivision ordinance, those are required, and the council is the one that can do that only. Establish the place and time of regular meetings. A majority of the full council can call a special meeting. Okay, so if 4 of you want a meeting, that would happen. We talked about executive sessions. Determining which services should be provided by the city and the fees for such services. You obviously act on those fee resolutions every fall. Looks like we've got some, you would adopt ordinances, so the mayor has some limited authority on quarantine. Beyond that, it's council. Franchise ordinances. Personnel policies. I'm looking for something particularly interesting. Licensing of businesses, of course, comes before you, and that is a quasi-judicial matter. So all that stuff we talked about on land use, it applies for licenses. Okay. Regulating, establishing license fees for license by the drink, vacating streets, preparing the budget, I guess it is there, approve the appropriations. Okay. Property tax levy, monthly report. All right, I'm going to skip through this stuff. It's all boring, you know, stuff that doesn't really create much controversy.
I think it's like setting the fee.
Okay.
Yeah.
Mark, could you just clarify, 4 of us can call a meeting, but then who sets the agenda for that meeting?
Well, good question. Right? I mean, we just talked about that. I think if you... You're right.
It just struck me as funny because...
I think inherent in that, there's, like I said, there is no law that says, here's how the agenda is put together, okay? Which means there's nothing that says the council has the authority to put the agenda together. But it also means the mayor, there's nothing from the mayor or the clerk, right? Or staff. It just, it seems to me, what I would advise all of you is, if 4 of you get together and call a special meeting, you're going to be able to put whatever on the agenda to do. You have to be, right? It's got to be an implied power, even if it's not an express power, right? But, generally the key is, we wouldn't have this here, okay? But you could have a council member who says, I want to pass an ordinance that says, under the 10th Amendment, we're immune from federal regulation, okay? That's not going to fly. You may have only 1 of 6 council members that want to have that on the agenda. It's probably not going on the agenda if that's the case. Does that make sense?
Yes.
But if you got 4 council members that want to see something, I don't think there's any way to not do it. And I would say that to the mayor in front of all the council members. I mean, if you got 4 of them that want to talk about it, then it goes on the agenda and it goes where it goes. I mean, they just have to have the authority as part of their meeting at some level to do that. So, or 3, or 2, or 1, right? If it's a good idea, right? I mean, the mayor, you could have Debbie put it on the agenda. It's just that there's some vague line between that outlier that's not worth our time and the thing that just simply has to happen for practical reasons. All right, let's talk about mayor and council relationship. This is really the only one where I've seen at times friction over the years. And it has to do with council members who become interested in the day-to-day operations of the city. There was a council member in Nampa who was a developer and builder, very interested in planning and zoning, right? If you had, I don't know, a retired police officer on your council, they may be interested in the police department.
Chris?
You're right.
We got to do it.
Right. The city handles its potatoes, right? But the point I'm making is it's not wrong for you to have that interest and to want to know. And so we'll distinguish between whether you've got an interest or a concern. You may be like me. We spend a ton of money on our wastewater treatment plant. I want to know what's going on. I just want to know how that works and what is it that they're doing over there. How do we treat water, right? And so you're just interested. If that's the case, I would say talk to the mayor prior to contacting staff. I want to have a tour of the wastewater treatment plant because I want to know how this works. Mayor, accommodate it, right? I think it needs to go through you because you run the day-to-day. But if it's just a matter of I want to learn more about what I'm doing here as a council member and why I'm spending so much money on wastewater, I just want the background information. That's something that's a good idea, right? It just should be accommodated. Then I think, talk to the department head, right? If the mayor gives you the green light, don't go to some low-level employee that's going to be freaked out when they see you walk through the door. Arrange an appointment, and certainly, they will accommodate you. And then learn, right? Use it as an opportunity to learn. If you've got criticisms after that, I think there's another way to handle that. You certainly need to talk to the mayor, about, I found this when I was out at the wastewater treatment plant that was of concern, Mayor. Mayor's responsible for day-to-day operations. That might resolve it, depending on what it is that you saw. I think you as council members can also raise that at a council meeting, during your comment period. I went and toured the wastewater treatment plant, and I saw this, and that's of concern to me, and I don't know if I'm the only one. Right, and that's perfectly fair. You can use that time for your council comments to raise that. My request would be that you be constructive, right? Critical only gets you so far, and if we're all wanting to fix the problem, then be constructive in your communications with the mayor, and your handling of it in your role as council and your communications from the dais. All right, last point. This issue about contacting staff and going through the mayor first does not apply to me or my office. We are the attorney for the city, not the mayor, not the council members, not any of the department heads. The city is an entity, and you guys are running the city at a high level, certainly, even if it's not day-to-day operations. And most of you have contacted me at some point for whatever, and I'm happy to talk to you about that. I don't think that you have to go through the mayor first. You may hear me say that you should talk to the mayor, but I'm happy to address that with you. So the rules about going through the mayor for day-to-day operations, I think there's an exception for city attorney. All right. questions? Look at the time, Mayor. We're good?
I have a comment, I guess. I think historically the mayor has said that if we want to talk to an appointed official, that's not something necessary to go through him to get permission to talk to them. And that's kind of a frustrating statement, I guess, since we do the appointment on the appointed officials. Feels like a little gatekeeping, if we want to be able to talk to an appointed official to make a tour of something. So if it's a Friday night and I'm thinking, maybe I want to go ride with the police department, then I have to call Jerem, wait for him for a week or however long, to come back to me and then make those arrangements. Seems like a lot of work. So I think there needs to be some discussion or leniency when it comes to the appointed officials as opposed to maybe a department head.
Yeah.
And I think I can jump in there, Mark, on that. I think that, there's that kind of, again, that fine line that you're finding. I think that reaching out for and we've talked about this, if you have a simple question or you want to go and do a tour, I think that's great to reach out. I think where it starts to become an issue, let's say if you're going to reach out to our public works director, but not a question, but some type of, say, a policy or something you want them to consider or look at, and then Councilor Allgood calls the public works director with a complete opposite. That's, I think, where if you're asking simple questions, you want to go and visit or tour, I think I guess that's my water bottle, more than free to do those things, and I think you should. It's where you're starting to maybe look at, some type of leading them towards a policy decision or looking at something different, where another council member may have the exact opposite, and it puts them in a tough situation of who do I listen to or which way do I go, and creating workload for them. So I think simple questions, wanting to reach out, I think, yes, please go ahead and reach out to those appointed officials.
That's a fair question. Let me put some context on that. These are guidelines, not rules or laws. Of course, use your judgment, right? And I'm thinking of situations, not in Caldwell, where a council member inserted himself into a department and started wagging his finger at city employees about how you were going to do this and that. It violated the whole chain of command and put the employees in an awful situation. I don't think any of you would do that, but that's why, to the extent it seems like it's gatekeeping, that's what's in my mind, not the ride-along. So, yeah, absolutely.
Just because we used the tour as the example, so I just wanted to be sure that wasn't something we needed to...
Yeah, no, that is just kind of my advice about how I think it should go. It's not going to be necessary in every communication, certainly.
I had a question, Mark.
Yeah.
Our situation here about a month ago, one of the county officials were chastising the city council on approving a certain subdivision that dealt with intruding into farm ground, and he said, don't blame us, talk to the county, or talk to the council.
City.
So I went out of my way to talk to the guy, the official, and told him, I said, look, if you folks hadn't turned the municipality water deal over to the city back in 2020, it wouldn't have been our problem or your problem. I said, every time you take a chunk of ground out of the county and let, maybe a half-acre subdivision go on there, it becomes a problem for us, and then we get blamed for it when you're the folks that approved it. So I just told them, you better watch your P's and Q's there when you're blaming somebody.
Yeah.
And it ended after that, but, I don't know should I have called somebody else or?
No, I mean, I think it's, my only concern, first of all, what you're talking about is a legislative matter, meaning, the relationship between the county and the difficulty that's presented by how they do their land use, which is long-standing, right? I mean, they, for years, and probably still do in their comp plan, had stuff that said, if you're going to develop some density, you should do it near a city. Well, that's where the city's going to grow, and that rural development is incompatible with municipal development.
Yeah.
Creates these land use conflicts. It's a good discussion to have.
The reason he called me, or I called him about it, is because they had a lot of backlash from the ag part of the business here in Treasure Valley about, doing that, and he said, no, it was the city council that grew, it wasn't us.
Yeah.
And that's how it started. So.
Yeah. No, I think that's fine. The only caution there would be, if it's in the middle of that, if it's already done, right?
Yeah,
then I think you're fine.
Okay.
All right.
Anyway, I tried to defend everybody on that one.
Yes, Councilor Allgood.
I was just wondering, I wrote down a whole list of questions. You bring up such good stuff. We definitely don't have time to hear it, I would love to do another one of these where we could ask a whole bunch more questions if we could get something. Yeah, absolutely, because, you know, I've been here a while, so I know some of the answers, but there's some very important ones that I would really like to have more discussion on.
Yeah, it was a lot, and so hopefully, that was one of my requests. If your wheels are turning, let's figure out how to follow up and get, you know, additional information to you. So, yeah, Mayor,
Any
we
other
can,
questions at this time? But yeah, we'll schedule another time for Mark to come back and we'll just do a Q&A on that. So, okay, thank you, Mark, really appreciate it. Okay, with that, we're gonna take a 5-minute break and we'll be back to begin our council meeting at that time.
Right.